My name is Chris Campbell, and I'd like to welcome you to this dialogue on the tension between arbitration proceedings and insolvency proceedings. The webinar features two renowned panelists in Professor Patricia Shaughnessy and Professor Loukas Mistelis, whom our moderators Ishaan Madaan and Prakhar Chauhan will introduce properly in a moment. Ishaan is an advocate of the Supreme Court of India with some 10 years experience in complex commercial litigation and soon to be a New York attorney at law. He's also a recent alumnus of the International Dispute Resolution LLM program at the University of Miami. Ishaan is the founder of Arbinsol, which together with the Center for International Legal Studies is the host of this webinar. Like Ishaan, Prakhar is a founder of Arbinsol. Unlike Ishaan, Prakhar has followed an academic path. He's an alumnus of the University of Lucknow and of the master's program at Queen Mary University, London. Prakhar is now himself a professor at Jindal Global Law School, specializing in international commercial, investment, and construction arbitration. Before I turn it over to Ishaan and Prakhar, a little bit of housekeeping. If you have any questions, and I hope you do, please use the Q&A feature, not the chat feature. The Q&A button is in the middle of the bottom of your menu bar. And with that, Ishaan, Prakhar, I will ask you to introduce our panelists.
So, ladies and gentlemen, welcome. These are largely unprecedented times and uncertain in many respects. One of the most organic consequences of such times is battered solvency of businesses and the likelihood of insolvency that is going to be triggered around the world. Several of such businesses would be parties to international arbitration proceedings and arbitration agreements. Insolvency around the world entails abatement and consequently nullification of proceedings. That would be the fate of arbitration proceedings, is that so? Or perhaps what would be the fate of arbitration agreements in the face of such insolvencies? What are the possibilities involved? Arbinsol has been working on promoting research, dialogue, discussion, and thought leadership on this interplay. CILS and Arbinsol's post-pandemic series has been building on this discussion, and today we are most honored to have two legal stalwarts to have a dialogue on international arbitration versus insolvency. Those who know of international arbitration know already of the speakers today. On one hand, we have Professor Dr. Patricia Shaughnessy, an international arbitrator. She's the founder of the ICAL LLM program at Stockholm University, and also teaches in other related fields such as comparative law, legal methodology, and EC procedural law. With both common law and civil law education, she is a senior Fulbright specialist and is a member of the board of directors of the Arbitration Institute of the Stockholm Chambers of Commerce. A student favorite, Dr. Shaughnessy continues to guide the youth in the ever-evolving field of international dispute resolution. On the other hand, we have Professor Loukas Mistelis, a noted thought leader and an acknowledged authority in international arbitration. He's listed on the Who's Who commercial arbitration since 2007. He's an ICAL arbitrator as well as the recipient of the Global Arbitration Report Award for the Best Arbitration Lecture of 2013. Professor Mistelis is the Clive M. Smithoff Professor of Transnational Commercial Law and Arbitration and the Director of the School of International Arbitration at the Center for Commercial Law Studies, Queen Mary University of London. Also joining me today is my colleague and friend, Professor Prakhar Chauhan from Jindal Global Law School, India. And thank you, Prakhar, the stage is now yours.
Thank you, Ishaan, for that detailed introduction. I'm glad to be moderating Professor Shaughnessy and Professor Mistelis. All of us have majorly known them as our professors, and only a very few of us have had the privilege of appearing before them when they were arbitrators. And it's today that we get to know their perspective on the intersection of insolvency and arbitration as arbitrators, and how do they, in their considered opinions, think this intersection works out, specifically given the fact that there are multiple stages in such proceedings and they are very complex in nature. And while making such an adjudication, there are multiple factors involved. We expect that Professor Shaughnessy and Professor Mistelis will also discuss on how they as arbitrators would balance these two distinct proceedings and move towards rendering an arbitral award. With these words, I welcome Professor Shaughnessy and Professor Mistelis to start the discussion and shed some light on how do they think, as arbitrators, this intersection works out.
Go ahead, Loukas.
No, also thank you very much for the invitation. It's a privilege to be with you in one of your first Arbinsol seminars, and it's a pleasure as well to have a dialogue with Patricia.
And I would like to join Loukas also in thanking the organizers and the participants for taking time on this Friday to join us. And I'm really looking forward to having a discussion with Loukas. I'm sure I will learn from it as well. And I look forward to all the questions and comments that the participants may join in to make this a lively event and a learning event for all of us.
Professor, the first question pertains to how you as an arbitrator generally are guided in such, what are the factors which guide you in such scenarios when you as an arbitrator are sitting in an arbitration where there is an allegation of insolvency after you assume your role as an arbitrator in the tribunal, and how do you go about these things?
Okay, I'm happy to go first on this question. The likelihood of an insolvency of either party, the claimant or the respondent in arbitration, although in most cases it will be the respondent, is akin to a nuclear threat. Arbitrators are being told that they have a duty to render an enforceable award. And of course, render an enforceable award against an insolvent party is an award that may never be enforced for practical reasons, not because the award is not enforceable as such. And of course, the second problem and the second consideration is one of efficiency. And the way arbitration works currently is that arbitral institutions expect parties to advance the cost of their arbitration before the tribunal can do any work. So this thing, efficiency and enforceability, which are the two sort of, if you wish, major principles of modern arbitral practice, come under threat at the risk of one party becoming insolvent. So in the context of institutional arbitration, you would expect that some of this preparatory work is being done by the institution. But sometimes you realize that this is not the case until the tribunal has been constituted and the parties have been asked to pay the advances, and then the money doesn't come forward. And the money doesn't come forward because the money doesn't exist. So the enforceability has, for the tribunal's perspective, not the concern as to whether there is money against assets against which the award can be enforced, but the concern of the tribunal is slightly different, is do we have genuinely a party that can participate in the process and comply with all the requirements of due process, the principle of contradiction, being able to put a case forward and deal with the case of the other side. And that could be either a party that has difficulties paying but technically can participate, or it could be a party that is no longer in full existence but is in some sort of, if we allowed a medical sort of analogy, on a life support machine, and the person who is controlling the life support machine was an administrator in the insolvency or a trustee. That person takes the control of the decision making of that company and may or may not participate. And again, it might be that there will be even an external lawyer appointed, or there might not be an external lawyer appointed. So all of these questions then become intense issues of investigation for the tribunal, and they're very fact specific. They're also law specific. We have to look at where this party is situated, what the relevant law is in that jurisdiction, how that domestic law would classify the situation. And I would perhaps, it's easier to talk about the historical case. In one of my first cases where I had to deal with the issue of insolvency of the respondent, the relevant law was Italian law, and Italian law has phases of insolvency. There was in Italian law, there's a distinction between concordado preventivo, which is some sort of a process of trying to save the company, not to become bankrupt. And there's the concept of fallimento, actually, that very much aligns with the English concept of failure and bankruptcy. So whether the concordado preventivo failed and you have a fallimento, then you have a bankruptcy. So the arbitration started when concordando preventivo was about to be introduced, but there was no fallimento. And that gray zone was, as a matter of Italian law, not too much of an issue, but we did have to have a full investigation. We had experts in Italian law and see how Italian law would look at arbitration proceedings pending that have been initiated before any insolvency process has properly started in Italy. So there's a level of, so there's one of the situations where the tribunal will sit down and take a deep breath or two, and then try to collect data, facts, and law, and be able to make a decision. And over to you, Patricia.
Well, I think that was a great overview of a lot of complex issues. Let me try to respond a bit. I agree with everything that Loukas said, of course, and I think he raised all the key things. And he noted the distinction between institutional and ad hoc without going into ad hoc. I think that if you're in an institution as an arbitrator, you're going to feel a bit more comfortable, although it's if you're ad hoc and you don't have any administrative body, then the only thing between the arbitrator and the parties paying their money is nothing. The arbitrators are saying, pay or we don't want to work. It puts the arbitrators, I think, in a more precarious and difficult situation. In the institutional situation, if the case has been transmitted to the arbitrators, then the costs should be advanced, but it's not unusual that the respondent comes in and raises counterclaims, and then there's a recalculation of the value of the case, which is going to generate additional requests for payments by the institution. And so while those additional requests are being made and maybe extensions are being given, the case is in the lap of the arbitrators. But I think there is a greater comfort if you're in institutional context than if you're ad hoc. When it comes to the risk, of the award and its enforceability, as Loukas pointed out, the issue is whether or not the award in fact will be able to be paid. And there could be some issues about whether or not it could be recognized at the place where the insolvent party has its assets, and so it may not be actually be able to be converted into a cash payout. I would say, generally speaking, that risk that the award might not get paid is a risk that the party who is advocating, move forward, we know there's a risk, we're willing to take that risk. And so as an arbitrator, I might not be too concerned if the risk is whether or not the party who is supposed to pay has the money to pay. But if the bankruptcy or insolvency proceedings raise issues of arbitrability, and we'll come into this, mandatory provisions of applicable law, public policy, if it starts to raise those things, then the issue of enforceability, I think, starts to raise a redder flag than merely the risk that the party who will be obligated to pay is incapable of paying. And we're going to be getting, I think, into all of these issues much more. And I agree with Loukas. I think at an early point when the issue starts to arise, it's really important that you have a proactive arbitral tribunal who begins to identify the issues and request the parties to respond to those issues and to provide the facts and the law which is necessary to do a proper analysis. And I think that one of the key things is characterizing what are the issues. As we'll get into, we have the issues of arbitrability, potential public policy, as Loukas pointed out, the due process rights of the party who may not be able to realistically participate. That there's going to be issues that, is this an issue of capacity of a party is the party that's there now actually, as Loukas pointed out, is it somebody authorized by the estate or the trustee? Are there issues about the appointment of the arbitrator? Capacity issues. And there's also going to be, in some characterize it as a validity of the arbitration agreement. We can go more into that, but I think we need to be careful about recognizing that the arbitration agreement might be valid, despite the fact that some claims under it might not be arbitrable. So we need to make a bit of a distinction there. So now I think I've added to the complexities without really adding to any clarity. So I will return the mic.
I think there's something that you said, Patricia, which is actually very pertinent. I think the distinction of the enforceability in fact and enforceability at law is for the tribunal, perhaps in the end, an easy decision to make, because it's the enforceability at law that is the concern of the tribunal. The enforceability in fact is the risk that the successful party has to take. But in looking at the various sort of ways of packaging or labeling the issue to be decided, or to be too technically correct, to legally characterized, and perhaps the most iconic case that relates to arbitration and insolvency is the case of course, Electrim and Juventi, which has sort of different life in Poland and Switzerland and the UK. And a lot of that became an issue of characterization. What is sort of what is the insolvency law? Is it a matter of substance or is it a matter of procedure? If it's a matter of procedure, then we only care about the law of the seat, because we've been told all these years, not me, that localizing the dispute and localizing the arbitration is the most critical aspect of the process. If it's a substance, it might have a relevance as mandatory law. But I just wanted to step back a bit and say something else, because Patricia made the point indirectly. When it comes to the impact of the insolvency on the arbitration agreement, we have the big question as to whether this is an international law matter or a domestic law matter. And it will be an international law matter if the New York Convention can give us an authoritative decision. Because the model law is the model law. It is being nationalized in order to have any validity. So I would forget what sort of perhaps, so if it's an international law matter, it must be an issue that the answer comes from the New York Convention. And the New York Convention, when it tells us about the validity of the arbitration agreement, it deals with that in two ways. One is in Article 2, which we all know that is in respect of a defined legal relationship, has to be some sort of ideally in writing, but it has been interpreted a bit more widely. And it's a matter capable of settlement by arbitration. And there was again, not all insolvency issues can be resolved by arbitration, clearly not. That's not the argument that is going to be put forward here. And then we have the Article 2.3 that the matter may not be referred to arbitration if the arbitration agreement is invalid, void, if you wish, if it's incapable of being performed. Incapable of being performed means that a party cannot fulfill the right of defense issues. So then we have the Article 2.3 exceptions, and we have the Article 5.1a, which also deals with the arbitration agreement and capacity of the parties. And that perhaps becomes an issue. So I think one could argue that an insolvent party cannot enter an arbitration agreement. It's an argument. But most parties would have entered an arbitration agreement before they were insolvent. And so the capacity to enter the agreement is almost never an issue, but the capacity to fulfill an agreement becomes then an issue. And therefore the New York Convention is not really determinative on the core of the issues, and there will be a bit of a dialogue. It's sort of using the word that is relevant to our seminar today, or has this sort of ping pong, if you wish, between domestic law, international law, domestic law, international law. And and somehow we have to localize that answer, and arbitrators would be always be guided by the New York Convention, because that's the comfort zone of all arbitration tribunals, but domestic law will be pulling that in that direction. I just wanted to make that point.
Great. Thank you, Professor Mistelis. Now, just narrowing it down from where you discussed it, what can be an arbitrator's view when they're apprised that insolvency proceedings in respect of a party have begun after their nomination as an arbitrator by the parties? And can it be subject to change if such proceedings are triggered after the constitution of the tribunal?
Well, I can jump in here. When you say after the nomination of the party, does that imply that this is a procedure like ICC, where there is a difference between being nominated by a party and being appointed by the institute? So
perhaps
that's
either of those scenarios where the tribunal has not yet been constituted.
okay. Mm-hmm.
And a party has nominated, and then they say, okay, listen, we are insolvent now. What should be done?
And that can be an important issue. One issue is the money. Arbitrators, it's no pay, no play. So arbitrators get concerned about the money, but I think most arbitrators are actually more concerned with doing the right thing and acting appropriately. And then the question is, did the party who nominate you actually have authority now to enter into a relationship with you as a arbitrator? And so if that company, that party has become insolvent, if they're formally insolvent, if they've gone into bankruptcy, then it may be now that the bankruptcy estate administrator or trustee must be the one to enter into the relationship. So there may be issues of power of attorney, there may be issues of the right of representation. It may be that the lawyer that's representing that party may also have issues regarding the relationship between them. So this becomes, it definitely sends up a red flag, and I think that most arbitrators would want to be very careful to ensure that they continue to be appropriately in a relationship with the party who's now in control of that entity. Loukas, has that happened to you?
That's a very tricky question. I think if I'm satisfied that the party that appointed me, at the time that they appointed me, had the capacity to make the decision, if the circumstances change, I wouldn't be too worried, because it does happen. I mean, what it has happened to me is something different, is that a party has nominated me and I was eventually appointed, and of course that appointment process goes through that party's external lawyers, and the party changes legal representation and uses new lawyers. I don't think there's an issue for me about not continuing with the arbitration. And I think there's a bit of a similarity in these two questions. So if at the time when sort of the appointment was made, the party could make the appointment, I'm perfectly fine. I don't think I will be tendering my resignation to be confirmed by the trustee or somebody else. That would be my immediate reaction.
Yeah, I think if it occurred after the constitution of the tribunal, so if it was an ICC, for example, and its Article 16 has been met and the file's been transmitted, then I would feel pretty comfortable that the issue is not whether or not I'm properly an arbitrator, but the issue then becomes whether or not this arbitration may be subject to some mandatory stay or not, or the issues, what they call the core or pure issues, or can the arbitration continue? Then you get into all the complexities of the problem.
I wonder whether we should take that issue first, although I know we were supposed to discuss it a bit later. I think it's very difficult for arbitrators to argue, and that relates to one of the questions in the Q&A, that arbitrators can take core insolvency proceedings issues to decide in the arbitration. I think for a very simple reason. In most domestic systems, arbitration is a collective process. So a company has failed to cease to make payments, and all of the creditors come forward and they bring their claims, and some of them are privileged, some of them are not privileged, and then sort of lists are being prepared. So once the assets have been liquidated, then one can see what recovery they can make. The classical scenario in arbitration is that the company which has a normal commercial activity finds financial difficulties, or an aggressive creditor, for example, initiates a process so that the company becomes bankrupt. Although perhaps there might be a bit of a period that one can withstand this aggressive creditor sort of process. So what the tribunal will do in that case is will decide whether, in this particular context, a claim that the claimant has in this case can be upheld as being a valid claim, and this valid claim and the award will be taken to the insolvency tribunal. And so insolvency laws have two characteristics. First, they are typically domestic. We have had over the years global insolvencies like BCCI or Parmalat, but most insolvencies are single jurisdiction insolvencies, and they're collective processes. So arbitration, the classical arbitration, is neither. So it's not collective, it's bilateral or trilateral, whatever the process could be, and is also not domestic, but has an international element. So there's a different sort of ideology, if you wish, is a different DNA, perhaps is the right thing to say, and that conflict becomes relevant. So tribunals will tread typically very carefully when issues come forward which might appear to be core insolvency issues. And I think very few people would argue that core insolvency issues can be referred to arbitration.
I think I agree with you. And when you get to those core issues, then you're definitely getting into the area of public policy, issues of transparency, and issues of having this administered collective creditors process. So I think that, when it becomes problematic is perhaps when the core issues are not so clearly defined and so easy to extract from the other issues. And we all know in law, that's often where we end up. That's where the discussion really ends up, where things are not clearly on one side of a line or the other. Let me ask a different question, since this is a dialogue. You mentioned when you have aggressive creditors who might be pushing to put a company that's maybe having difficulties in pushing them into a insolvency proceeding. If that aggressive creditor is the claimant in the case before you, how do you respond to that? So that there's an arbitration going on to collect the debt, and that claimant now carries a parallel strategy to push the respondent into a bankruptcy.
That's not unusual. An aggressive creditor could have such a claim that if the claim were ever to be upheld, then the company will go bankrupt. So your award will make the company bankrupt. I think in most of these cases, and if we stick to that sort of inverted commas aggressive creditor scenario, normally the respondent would have a reasonably good defense. So I think in the one case that it has happened, and actually the aggressive creditor, one of the reasons of putting the respondent in a very difficult position, there were multiple proceedings. There was the arbitration, there was proceedings against officers, personal claims in different jurisdictions. Effectively, it was really a sort of it was not just an enforcement of rights, but also a collective bullying of the other side in different ways. So there is a bit for the tribunal to make sure that the parties are being protected, but also if that party, the respondent party, is legitimate sort of in the defense, they would normally have a good defense, I found. So in the one case that happened to me, I know of other war stories, but in the case I have experienced, the respondent put up a good defense, and actually the case has ended somewhere where, of course, there was not a bankruptcy of the respondent, but the respondent had to collect something, and then there was a settlement post-award, which I think is the best possible scenario.
Professor Mistelis, I just wanted to add a question to this. How do you see this, and this is for Professor Shaughnessy as well, how do you see when, what happens if there's a role reversal? Say, for instance, what happens, how is your approach when the claimant is undergoing insolvency proceedings, and what is your approach when the respondent is going insolvency proceedings? Have you come across situations like these?
Most of my experience was with the respondent becoming insolvent. There was a single case many years ago, perhaps 18 years ago, where the claimant actually was to enter into insolvency proceedings, and the case was brought bona fide by the claimant. Then it was continued by the administrator in the insolvency, because they thought they would collect out of this award, and this will go to the collective sum of money for the insolvency. It is good for the tribunal just is not a court of law, sorry, I have to be a bit philosophical here. Arbitration is not the pursuit of truth. Arbitration is the pursuit of justice, and so the investigative powers of the tribunal is not such that we ask every single question that we would like to know about the parties and the position, but everything that relates to the claim or the defense that the parties are putting forward, and that on the need to know to make a decision. So that's my standard, is what I need to know in order to make a decision, not what I would like to know. And that's not always very easy to delineate, but you simply sort of investigate, and you might not need to know some questions which might paint a picture of the party which is not necessarily favorable to that party. So that balance is not always very easy to draw, and therefore, from my perspective, it doesn't matter which party might have financial difficulties. That's why I think I prefer the institutional arbitration context, where I don't have to write to the parties as a presiding arbitrator and said, look, you haven't paid the advance, so we cannot proceed, and can you pay the advance? So that's something that is in an institutional context, the institution does, and keeps that buffer between the tribunal and the parties, which is very, very important, because some of these communications are not pleasant for any party involved, not for the arbitrators, not for the parties.
Professor Shaughnessy, your opinion?
Well, I can only agree with what Loukas said, and as in the introduction, as was pointed out, in these COVID times, there are many companies that are experiencing disruptions, and those disruptions are also affecting their cash flow and affecting the continuation of their businesses. So I think that it's not unlikely that we may see some claimants whose situation has changed dramatically since when they commenced the action, perhaps, and then they run into financial difficulties, and that raises, when we start talking about claimants who have perhaps have cash problems or asset problems, and that takes us right into the security for costs discussion. And when should security for costs be allowed, and what degree of evidence needs to be provided regarding the situation of the claimant to justify a security for costs order. I don't know if we want to unpack security for costs now, but it's probably likely to be seeing more such requests in the time to come. By the way, I see we're getting a poll share here.
Good.
Yes, this was a question raised initially at the beginning.
Yeah, I just thought I would share that quickly before we were too far beyond the initial question. But I think it looks like about a third have been involved in that kind of a situation if you include the not sures. But
Yes.
yeah, no. Good.
At least a quarter, so let's say.
Or a quarter, yeah, a quarter. Yeah. There we go.
Moving on, I gather this from the specific point which both of you were pressing on of core and non-core issues, and with respect to core and non-core issues, insolvency being a centralized process. We talked about collective processes and the role of the trustee or the insolvency administrator. My next question actually flows from the previous discussion itself. How do you, as arbitrators, how do you, as arbitrators, take your relationship with the with the insolvency trustee? Because the question on security for costs is actually a detailed one, and that may not be addressed. But how do you see that relationship and the interdependence in your arbitrations? Professor Shaughnessy?
Sorry, I was looking at the poll question that popped on my screen.
Sorry.
Yeah. No problem. Yeah, so the question that you asked, could you repeat it, the last sentence that you made?
It was essentially on the interrelationship of or the dependence which the arbitrators and the insolvency administrator or the trustee have with each other, because we see a lot of non-core issues also being picked up by the tribunal, the core issues being reserved under legislation for the insolvency administrator, and in cases there are orders for security for costs, depending upon who's facing either the claimant or the respondent, this relationship becomes all the more critical. So how do you view it in your experience?
Well, fortunately, I can say I haven't had the problem of having to decide as an arbitrator whether or not to do a security for costs order against a claimant that was in or about to go into bankruptcy proceedings. But once there is a trustee or a bankrupt estate administrator, then the ability for the estate's assets to be used to fund an arbitration is really something that I think is beyond the power of the arbitrator to decide. So the arbitrator can decide about the arbitration, but whether or not actually assets will be dissipated from the estate to pay the creditors to fund the arbitration has to be something which that takes us back to what Loukas said earlier. In most situations, it's going to be a domestic arbitration, and then you're going to have to look at what does the domestic rules provide regarding the authority of the administrator/trustee, or do you have to have a court that, if it's under the supervision of a court, does the court need to approve this? But in any situation, the arbitrator's not going to be able to impose a requirement that those assets come in. The arbitrator may say, if the money isn't paid, we're going to stay, or if the money isn't paid, we're going to actually dismiss the arbitration. But the arbitrator cannot control diminishing the assets to the creditors, and that's where we have this intersection, which is fascinating and troublesome, because we have the different interests between the state in having the controlled determination of the assets and the creditor's rights versus the arbitration, which is only dealing with perhaps one creditor's obligation. So that's a difficult issue. How about you, Loukas?
Okay, I mean, actually, I will bring into a question that came from a student, Rakesh, as well in that answer. The way I understood Prakhar's question is to have at least three elements. One is how you treat the administrator or trustee in insolvency, whatever you want to call it. And Of course, there's a little bit of a nuance to this question, but the essence of the answer would be, a nuance to the answer, but the essence of the answer would be that the trustee, if she comes forward, ultimately represents a party. So it doesn't matter whether it's a trustee. For me, it's just a party, somebody acting for the party. The real question would be whether I have the feeling, or the tribunal has the feeling, that this trustee doesn't have the capacity to fully represent the party, because either, I mean, there are jurisdictions, for example, where there's a distinction between what they call a property administrator and a full trustee in bankruptcy. So the property administrator effectively only has some sort of a looking at the assets and make sure that no activity happens that should not have happened. That person may or may not be legally trained, may or may not understand the issues of the arbitration fully, and therefore I will have a bit of a question as to whether I take that prima facie as being the party, or somebody who is a sort of effectively a placeholder for the party. A trustee, especially in jurisdictions where the trustee is typically a lawyer, or is perhaps maybe a big firm of accountants, any of the big four, or any of the big whatever you want to call them, then you would assume that they have enough knowledge to know what they have to do and how they have to deal with that. But I would not give the trustee more a different sort of leverage than the other party, because that I will automatically create an imbalance towards the other party. But I need to see whether we have potentially an issue of equality of arms, because although we say that the tribunal has to take the parties and the lawyers as they come forward, if a party clearly cannot represent itself, is either in default or de facto default. So it might represent itself, but not in a capable fashion. And therefore, you might think that you have to ask some questions to the other party to just do a bit of the investigation we have to do. That's one of the aspects of the question I've seen. The question of the security for costs, I've seen it in my practice in two different ways. I've seen it in investment context, where the investor has suffered an alleged expropriation or alleged unfair inequitable treatment, and eventually lost all their money that they have invested in that jurisdiction. And the state comes and says, look, you are this small company from the Netherlands, and you really have no much assets apart from what you're doing in our country. And now you are claiming this case for us. You must have somebody behind you, which is not a third-party funder, or could not find the third-party funder. You have to advance all the payments. Almost all tribunals, with a couple of exceptions, have taken the view, well, the state can pay for their defense. Even poor states can pay for their defense. Sometimes poor states pay more for their defense than rich states. Unfortunately, that's a different question, a different matter, or a different discussion. I would have a certain hesitation to grant security for costs. And I have had in commercial cases, a couple of cases where one party says, look, the claimant, if you look at is a listed company, but if you look at the last balance of payments, they really have not made any money in the last year or two. But the listed company typically has enough assets. And when we have been pushed to issue security for costs, and under English law and with a tribunal which is entirely English, the answer was not. It's a listed company, it has assets, it might not have liquidity, but it's not bankrupt, it's not formally bankrupt, no security for costs, because that will protect the integrity of the process and sort of. So there you try to be sort of fair, and you try to be balanced, and you hope that you succeed in doing that. But you don't want to, in trying to be balanced, to automatically sort of break the equilibrium that should exist in an arbitration. But for me, a trustee is a party. If the trustee comes forward as a representative of the party, is a party. It doesn't make any difference.
Professor Mistelis, on one side, of course, there is a trustee. And what if two parties, like a trustee appointed lawyer and a management appointed lawyer, come forward and they both seek to represent the same party? How do you confront that issue?
I would have a hesitation to answer that because I'm involved in a case which has a bit of that current issue at the moment, where there are two respondents. One is represented by a sort of trustee in whatever in that jurisdiction is, but there's a sister company which was a signatory as well, and then there's also some issues there where there's a difference between management or the proper trustee and the property administrator, and the tribunal sometimes arbitration is very quick. So in that particular jurisdiction, the courts are still dealing with the reappointment of the administrator, while the tribunal is almost ready to make a decision. What do you do as a tribunal? Do you just wait, or just to make a decision? So that's a current issue I have, and therefore I would not like to say too much. And
Professor Shaughnessy, just a neutral opinion.
Well, a neutral opinion is, I guess, what you're at that point doing is you're asking the tribunal to decide who has a better right to represent the party. Mm-hmm. And that's a difficult issue. And then you could say, well, is that an issue which is now pending in the court? Loukas indicated in the scenario that there's a court dealing with that issue. And when you have a court, we have a parallel proceeding on an issue that's relevant to an arbitration, and you know the court's going to take a long time, then it becomes that classic problem for the tribunal. Do you wait for the court? And again, whether or not you wait for the court to make a decision may have to do with whether or not that's the court at the seat of arbitration, or then when we're going back now to what we started with early on, which was the electrum issue. Are we more concerned with the seat of the bankruptcy, or are we more concerned with the seat of arbitration? And if you're more concerned with what the seat of bankruptcy has to say about it, and that's the court that's going to decide who has a better right, then the arbitrators may have their sights there. But if you're saying, well, I'm only concerned about the seat of arbitration, what does the seat of arbitration have to say about this? And if that gives me the power to decide, yes, I can go ahead and issue the award. But what you may end up in many jurisdictions, you're not going to find any directly applicable law on this issue. And then you're going to have to try to make...
There's interesting enough a question from Weronika Rydzinska, who comes from Poland, and sort of in the Electrum Vivendi case, there was an ICC arbitration and an LCIA arbitration. One arbitration seated in London, the other arbitration seated in Switzerland. The English law understands that matter to be a matter of procedure, and therefore the Polish law is irrelevant. The Swiss law considers the matter to be substantive, and therefore Polish law becomes relevant. So the law of the seat is irrelevant. As you know, Switzerland has one of the broadest arbitrability provisions that there are. But by passing the question as a question of substance, then Polish law comes as mandatory law, and then we have to stop the process. The English would not stop the process. Of course, I understand that Polish law subsequently changed, and therefore an insolvency does not stop arbitration commitments of an insolvent company. And my understanding is that, not my understanding, my knowledge is that the revision of the Greek law would feature a similar provision. There's a draft new arbitration law, which is based on the model law, but one of the additions that they would have is that an arbitration, an insolvency process would not interrupt arbitration proceedings. So I think the seats are, especially if the arbitration is one of these major arbitral seats, the process would be quite relaxed as to what happens to insolvency, and similarly, I think there would be an issue as to whether the domestic law, the the insolvency law makes a distinction between international and domestic arbitration. In my case, the fallimento concordato preventivo, the Italian law practice rather was clear in the Court of Cassation that we do not interfere with international arbitration, we let it run, but we do stop domestic arbitration. So the seat of the arbitration in that case was in London, and that was the end of the story. So we were unaffected.
I'll venture maybe not so provocative, maybe a little provocative opinion, and that is that when we're faced with these issues where the answer could be plausibly, we have to give more respect for the bankruptcy or insolvency proceeding, or plausibly, we have to give more respect to the international arbitration proceeding. And I would say that generally, maybe being a little provocative, that given the favor of enforcing arbitration agreements and ensuring the integrity of arbitral proceedings, particularly once a tribunal is constituted, talking about an arbitration agreement that was entered into prior to any potential loss of capacity or entered into by a trustee. And given this presumption of validity of an award and such, I think that international arbitration should generally go forward and its integrity should be retained. And that doesn't mean that we should disregard the insolvency issues, but when they're in conflict, I would be inclined to want to advocate that we for the same reasons that we see the doctrine of separability, for the same reasons we see this idea that the allegation of corruption or the allegation of a fraud or the allegation of a termination of an arbitration agreement will not automatically put the brakes on arbitration, but that we favor the continuation, because otherwise, particularly when we get into a financial crisis period as we're perhaps coming into now, it's very easy to derail and disrupt an arbitral proceeding by threatening insolvency. And again, we have different kinds, as you've already pointed out, Loukas. We have what you might call the restructuring of a company or the actual liquidation. And companies may go into restructuring for all kinds of reasons as a result of this current pandemic, and that could be abused with disrupting ongoing arbitrations. So being a little provocative, and nobody can hold this against me if I'm in a real case with a real issue.
But the question is also, as you say, you have to weigh the circumstances and you see whether the domestic matter is being internationalized so that it's been taken out of the remit of the courts purposefully, and that's perhaps an issue that tribunals have to look at. But if the arbitration is a genuine arbitration, I don't think there's too much of an issue. And I find the results very interesting that 50% is clear that tribunals should have the power to proceed. I'm convinced quite a number of people, I think, and I'm not sure if you add that to that is almost getting 3/4. Yes, why not? Let's go ahead. And only 1/4 is negative. Very, very, very interesting result.
It was actually interesting to see the numbers shift as the two of you were talking. So, you seem to be a bit persuasive.
No, I think if the purpose of the arbitration is for a creditor who has a genuine claim against a respondent who might suffer insolvency proceedings in a domestic court, and the tribunal can quickly sort of find whether the claim is valid or not, then you just take that award and you try to enforce it with the rest of the insolvency claims. If arbitration is to the extent that arbitration can be efficient and quick, that's perfectly fine. And in the case I told you with the dispute between the two parties, who is the real sort of has the right to represent that insolvent party, the tribunal was very quick. It was a substantial claim because it arises out of a very, very substantial loan agreement. But it could be done on documents. It could be done very, very quickly. while sort of the court still decide who could be appointed for what purpose for how long. So yes, then in that case you have a dialogue between an arbitration and domestic courts. I mean, they work hand in hand rather than against each other.
This, in fact, the way Professor Mistelis summarized it was very pointed and very targeted. And in fact, Professor Shaughnessy summarized all of the questions in her opinion when she took up all of those issues, because there's this. I mean, they are so inextricably linked that it's very difficult to segregate them threadbare and then assess them. But there's this one thing which I picked up, and that was very interesting in my opinion, that an insolvency, as it is alleged on day one, it's either that the party is incapacitated, which the arbitrators pointed out. The second thing is that there is an allegation of insolvency. One of the person comes and says, "Oh, this person is facing bankruptcy / insolvency proceedings in their own jurisdiction. Please halt this arbitration." As arbitrators, to what extent do you go down to investigate the veracity of that allegation? Because the party before you could be the respondent who's facing it, and then there's a strong likelihood that he might abandon the arbitration, and then the claimant, as it was put out in Rakesh's question, that then you have to proceed ex parte, or the claimant is the one who's facing it, and the respondent presses for it. So, to what extent do you go on to investigate it as to it's not a mechanism for arm twisting arbitration?
I think a tribunal has the duty to investigate. I mean, if insolvency is alleged, I will need to see evidence. I need to see evidence from a domestic court and an explanation of how that domestic jurisdiction operates in relation to these matters. I will not just be satisfied by a mere allegation.
Professor Shaughnessy?
Yes, and again, if the allegation is that they're insolvent, as in they're impecunious, as in they don't have any liquidity, they don't have any assets, then I think that's different than an allegation to say that they have formally entered into some sort of state-administered proceeding, insolvency proceeding / bankruptcy proceeding. If it's the latter, that should be something which could be pretty easily confirmed, whether or not there is a proceeding in some jurisdiction going on. If it's the former, saying they don't have assets, and then the respondent says, yes, we do, and the claimant says, well, show them, and the respondent is like, well, we don't want to do your homework. They tell you where all the assets are, so that if we lose this arbitration, you'll know exactly where to find it. So I think you have to kind of make a distinction, and you have to say, if the claimant makes such an allegation, then as Loukas pointed out, I think that the tribunal needs to say, what is the basis of your allegation? If you're asking us to request the respondent to provide some financial information, we need to know why respondent should be required to do that, because normally you're not required to do that when you're arbitrating if they paid their costs and they're participating. If it's a case of a non-active or non-responding respondent, that occurs unfortunately not so infrequently, and it doesn't always necessarily have anything to do with liquidity. It can be that they make a choice not to respond for different reasons. And that's always puts a tribunal in a difficult position, particularly if it's a sole arbitrator, which it probably happens more frequently with a sole arbitrator, because then you're in the position of having to retain your impartiality and objectiveness, but also being mindful of the due process rights of the non-appearing respondent. So that's maybe a topic for a different seminar. But I think that whether they're not responding because they allegedly don't have the money to pay for counsel and to actively participate, or if they're not responding for other reasons, I think you have to tread very carefully in both of those instances.
Yes, and there's a slight difference in the full default. I'm not participating because I have no assets, I have nothing to defend, or I participate somehow, but I'm not putting a full defense. So I've just make things a bit more difficult for you. So I'm replying to certain sort of communication from the tribunal, certain communications, but I'm not represented fully. That's a bit more complicated. Perhaps it's even as bad as being represented badly, sort of not effectively. So, but all of these states exist in reality.
But and if the claimant is concerned about the respondent's lack of assets and there's no the domestic bankruptcy or insolvency administration going on, then it wouldn't be unusual that the claimant would be asking for an interim measure on an asset freeze or an interim measure to get some assurances or some insights into the financial situation, saying that you would like to have a copy of records and things. So it would more typically, I think, appear as an interim measure request.
Yeah, and I think objectively experienced arbitrators have had quite a bit of exposure to sort of some of these tricky questions, and they know the type of questions to ask. I mean, I know perhaps that's not en vogue, but that's one of the arguments for the more experienced arbitrator, not necessarily experienced as an arbitrator, but experienced as in legal practice experience, sort of reading between the lines, which could be a young person. But yes, there's certain advantages there.
Interesting. Do we, and this is the last point which I want to raise. Do we also see sham arbitration proceedings being initiated by parties who are facing insolvencies just to tinker between and involve into forum shopping? Has that been a case in your experiences?
Actually, a few years ago, there was apparently enough concern that the American Bankruptcy Institute came out with advice that there were, but this is not so much commercial, but more credit card debt, where there were companies that were sham arbitration institutes that would sell services for indebted customers to these credit cards, commercial or consumer, that could enter into they would send a check saying that this is in full satisfaction, and then they would say, and we're making a change to the contract, any disputes going to arbitration, and they would have this sham arbitration institute. So that was actually some kind of scam going on some years ago in the US, and the ABI had came out with recommendations to creditors how to deal with that scam. But I think that's separate. We'll park that. That's something different. But there is some reports, and there have occurred some situations where there have been one party putting, as Loukas called them, the aggressive creditor, who might be trying to force a company into some kind of administration for restructuring or bankruptcy to deprive it of its right to have its control over the assets. And then in doing that, and I can think of at least one case where the court in another jurisdiction appointed the trustee receiver, and that trustee receiver appointed the arbitrator, and then the company went to court saying that this was a sham, and this was a basically trying to steal the company, and then saying that in the court in another jurisdiction, because it became multiple jurisdictional, found that that was an improper appointment of the trustee, and that it was applied retroactively, so that the appointment of the arbitrator no longer, according to this other court, was effective. So you can see that in that case, it was alleged that the insolvency proceedings forcing the company into receivership was a sham to try to take over the company. And we've heard reports on, in some jurisdictions, these kinds of shams going on to do that. We also have seen some cases. There was a case at the Swedish Supreme Court about 15 years ago in a bankrupt proceeding, that a party brought in a arbitration award giving most of the assets to someone else, and the Swedish Supreme Court considered that to be a sham arbitration award. It was from a non-institution. It was a sole arbitrator that appeared to have some relationship with the party, and the whole thing seemed to be the court didn't actually call it a sham, but it's clear from reading the judgment. And the bankruptcy court rejected the award as removing assets from the estate. So the sham can be on the point of bankruptcy proceedings, or the sham can be the arbitration proceedings.
Yeah, yes, because I mean there is this sort of fairly recent sham arbitration involving Chevron, where in Egypt, where a non-institution with arbitrators who were not particularly well known or unknown, although the people who were involved in the beginning, brought a very substantial claim against Chevron, and there was nothing to bring them together. But on the aggressive sort of creditor, I mean, what I had in mind was a particular case where a former principal brings a case against a commercial agent with a view of not just sort of taking the agent out of work, but also taking the network of business that the agent has created in that particular jurisdiction. Of course, in systems where you have some protection for commercial agents, you get sort of a year's worth of money, but you can sometimes fabricate or organize a claim to be much bigger than that, and still get the other company out of business. So there are some of that, and one has to be very, very careful. But I think Patricia is entirely right that all of these sham arbitrations will typically be non-institutional arbitrations, very often some sort of ad hoc systems, and will involve people who are perhaps not the names that you would recognize in the arbitration circuit.
Professor Mistelis, there's a very interesting question, and perhaps both of you are well placed to answer this. It comes from Alexis, who says, about in cases of recognition of the insolvency order in the country of the seat of the arbitration, for example, in EU, it's automatically recognized by the member state courts. So how do tribunals then look at it, in a jurisdiction where there is by law recognition of an insolvency proceeding already? And how do you look at it when you're sitting at another seat in the same zone, say, for example?
In Europe, where, of course, I mean, we often criticize Europe, but of course, there are a lot of good things about Europe and the EU. There is this European insolvency regulation, which seems to say that the place first seized really takes control of the whole arbitration process. So if you know that what qualifies as because there's a list of whatever qualifies as insolvency proceedings, if somebody else has been seized first, even if it's an arbitration tribunal, then there's a line of command and respect there. Of course, perhaps one can argue that certain attitudes towards arbitration have changed in the EU, but not really. And therefore, you would recognize on that order. Of course, the burden of proving that this order is relevant and valid is on the party bringing it forward. And that's what I would expect from the party sort of bringing forward the order. And I think the tribunal would normally reflect it. There was also a question as to whether there have been anti-arbitration injunctions in order to protect domestic insolvency proceedings. I do not know of any, but it doesn't mean that they don't exist. They might still have been, because that's the extreme way of doing that, and an effective way of doing that. Not always effective, because in the only case I have been involved, which involved an anti-arbitration injunction, the anti-arbitration injunction was in a jurisdiction where only one party was linked, and the other parties, the arbitrators, the lawyers, were not sort of worried very much, and the arbitration went ahead. So I think there is the historical tension between arbitration and court proceedings, the way it was in the 19th century. I mean, in the golden era of arbitration, which was perhaps the 20th century, and not the 21st century. They have understood that they have to work hand in hand, and I think there are cases where there has to be a level of deference, so that you appreciate that another body has sort of a better position to answer that. So to the extent that you do not deny the parties what they're entitled to, which is the determination by the tribunal, where there's a genuine entitlement, then you defer some issues to the national court. I wouldn't have any problem with that.
Professor Shaughnessy, any insight on that from your perspective?
No, I agree with Loukas, and I guess one of the earlier things that was on the Q&A is because we talk about these issues as not having one clear answer when they involve different jurisdictions and different characterizations of the issues and different applicable laws and such, and whether or not that applicable law provides a mandatory requirement or not. So someone asked, should there be more legislation? Does this need to be dealt with legislatively? And we can say, well, we do have as Loukas pointed out, the European Insolvency Regulation. We have UNCITRAL model law. We have a UNIDROIT project going on. And maybe Toby Landau uses the term legislative-itis, that we like to think that we can legislate solutions. I'm not sure if we're ever going to get to the point where these issues are going to be capable of this intersection between arbitration and insolvency, that we could ever have legislation of all the issues. So we would, at the beginning of this, you talked about the uncertainty and the unpredictability. I'm not sure if we can get there, and maybe some legislation taking into consideration some of these issues, perhaps, but I think that this is going to be something we're going to see tribunals grappling with, and that it's good to have a tribunal that's proactive and that is capable of trying to identify the issues, characterize them, and require the parties, to the extent that they're participating, in informing the tribunal as to the arguably relevant law and facts. So I see this continuing to be an area of research, case development, and uncertainty.
Thank you so much, Professor Shaughnessy and Professor Mistelis. All these things what we heard today could not have been possible in a classroom, for sure. When we get to see you as arbitrators and sharing your opinions into how you would pursue a matter and discuss it. I mean, I completely agree that it's not, we can't encompass all of these discussions in 1 hour, because it takes much more than that. And as suggested, issues of collective proceedings, core, non-core issues, countries going on to legislate on all these issues. These things need to be discussed, I guess, threadbare and independently, rather than taking all of them in a blanket explanation. I sincerely thank you for your comments and your feedback. I leave it to Chris to have a final word on this.
I certainly can't top what we've already heard if I don't turn my mic on. But I'd like to thank all of you for your insights, for organizing this, Ishaan and Prakhar, and for all of the attendees for joining us. I think I've already mentioned in one of the responses that there will be a recording, which I think will go up on the Arbinsol YouTube channel in about 24 hours. And I think Arbinsol will be organizing a few more interesting webinars over the coming weeks and months, and hope you'll join us again then. And with that, have a wonderful evening or afternoon, depending on where you're at. Until the next time. Thank you.
Thank you. Thank you so much, Chris. Thank you so much, Professor Mistelis. Thank you so much, Dr. Shaughnessy. It was indeed great. It was indeed insightful. And as Prakhar was saying, this was a masterclass. And discussing issues that you won't find in classrooms, discussing issues that you won't even understand, even after spending hours on reading commentary about it. So that was fantastic. And we do look forward to more discussions and interactions with you. especially.
Congratulations on your initiative. Arbinsol is a great idea. As you know, there have been already a few writings on the topic, but there is so much more going on, and is wonderful that you have provided that sort of format and platform for debate, and that Chris Campbell is also supporting you very much in that with his ability to run events, which is unparalleled.
And let me also thank you for inviting me to join, Loukas. It's always a pleasure to be on the same stage as Loukas, even more if it were live. And I really appreciate the initiative. And thank you to all the participants for coming. I look forward to this continuing to be a robust discussion. And Arbinsol, I think, is a perfect platform for us to try to get a little more clarity.
Absolutely. In fact, that's the idea, to get thought leaders like you together on the same forum and, discuss perspectives. I understand we always have considerations that we have to take care of as academicians or as professionals, as arbitrators. But I think the more dialogue that takes place here, it can really help in, what people are asking, legislative reforms too, to some extent, and understanding these issues from both theoretical and practical standpoint. And after this pandemic, we're going to see a lot more issues, perhaps some which are, we're going to venture into uncharted territories, so to speak. So it's going to be really interesting. And we have to do more discussions and debates like this. Dialogues, must I say.
Yeah.
Great.
Thank you.
Okay. Thank you very much.
Bye-bye,
have a great evening. And until the next time, it's been good seeing you. Don't see as many people anymore with all these travel restrictions.
Exactly.
But the good thing is we do get to see such people because of the travel restrictions.
Well, yes, that we wouldn't perhaps see if we were traveling. That's true. That's true. It has to see the silver lining. So, yeah. But this has been nice. I've enjoyed it just from that perspective, aside from all the stimulating debate. So, really very good. Thank you.
May I just make a quick comment? If Anonymous is still in the room and asked me for the citation to the Swedish case, I don't have it at my fingertips, but if you send me an email, if you Google me, you'll find my email. I'll be happy to send you a copy of the citation to the case, and also an article that was published in the Journal of International Arbitration after it came out.
And please don't forget to mention yourself as the Anonymous who asked the question.
It's important for all of us as well to read it.
Yes.
Thank you, professors. We look forward to having more discussions on more nuanced topics subject to your availabilities, and take this discussion forward.